Good afternoon, ladies and gentlemen. Welcome to our panel, which will deal with international arbitration to be introduced in force to India. My name is Axel. I have the honor to moderate this panel of quite illustrious people. And I will start very quickly because we are the 8 of us and you want to get the wisdom of each and every one of them, I think. The first speaker I'd like to announce and invite to give her presentation is Lata Krishnamurti, an eminent Supreme Court lawyer of India. All the Indians and many foreigners know her, and she will give us an overview of dispute resolution in India, past, present, and future. Lata?
Thank you, Axel. It's a great pleasure to be here with you, and I want to directly plunge into the subject because we have very little time, as Axel already pointed out. Happy Law Day to everybody here, and it's a very, very special occasion, and I'm so honored to be here on this day. Now, as you know, the Arbitration Act is still, something with so many loopholes, and there were some of the loopholes were set right by judicial pronouncements. But today, the Indian Law Commission has come up with some proposals to make it better and bring it in line with international standards, and also to make it more effective. As of now, the main thrust of the proposals would be threefold. One is to contain the delay in the arbitration proceedings, which now go on like court proceedings forever and ever. So they've prescribed time limits under the amendments under the proposed amendments, I should say, to kind of contain the delays. For instance, an interim order which is obtained under Section 9 of the Act can be valid only for 60 days. So you can't get an interim order and sit forever and ever. Now, even an arbitrator who's appointed will have to, first of all, assure, if it's a domestic arbitration, that he'll be able to complete the whole, arbitration proceedings within 24 months, and he's given 3 months thereafter to give the award. Then if the Supreme Court, if they go to Supreme Court for the appointment of the arbitrator, within 60 days, they'll have to appoint the arbitrator. So some things have been done to kind of specify the time limits, and then they've said repeated adjournments would mean costs. If you ask for unreasonable adjournments, unconscionable adjournments, then you're going to be responsible for paying the costs of the proceedings. Then so far as the interference of court is concerned, they've minimized it like anything. They've said that no, the courts and the arbitral tribunal will have equal powers when it comes to giving interim orders, for the protection of the property or for any other urgent relief that is required pending the arbitration proceedings. So therefore, one of the things they've done is to kind of pay costs to cut down on the delay. Then there is another provision which they are seeking to introduce under 6A, where they are going to say that the person who loses the litigation will be asked to pay for all the unnecessary delays and counterclaims he's made. And for this, of course, they'll evaluate the conduct of the parties throughout the entire proceedings and then decide if somebody is guilty of having deliberately delayed the proceedings, and then they're going to impose costs, which is the most effective way of making sure that people don't transgress the time limits. Apart from this, there is one other thing which this act is trying to do. The present act as it exists is totally neutral to the institutional arbitration. It is not at all very popular in this country as of now. It is slowly becoming popular in some parts of India, like for instance in Delhi, many of the disputes are being referred to arbitration tribunals. And the power of the court to determine whether or not there is a contract has also been reduced. They say if there is an arbitration clause, the prima facie, if you see that there is a contract, whether it's null and void or whether it's wrong, or these are things that has been determined by the arbitral tribunal, and you will not waste time doing all that in the courtroom. So more and more, it's less of court and more of arbitration, and they've said that institutional arbitrations should be encouraged, and they've given power to the Supreme Court under the proposed Section 11 to say that either the High Court and the Supreme Court could refer matters to institutional arbitrations because it has a structure, it has specific rules, and so there's some kind of definitiveness about the whole thing, and they want they've also stipulated the fees so far as domestic arbitration is concerned to a structure, a model code, which they have produced in the Act itself as a schedule, to say that, of course, the last word is with the High Court, which will form the rules, but they have given us some sort of a guidance as to what should be the price, and they've also said there should not be, sittings unnecessarily. The electronic method of trying to, an arbitration should be in writing is a requirement under the Act. They've said that this can also be electronic writing to take advantage of the technology and speed. So these are some things that they've said, and there are many things. The second round, if I have time, I'll tell you. There are many things there in the institutional methods. We, as of now, have only developed rules in Delhi. The FICCI, of course, is a very popular method. Now they're encouraging more of the trade groups as well as the Chamber of Commerce to come up with rules which will be practical and effective and which can be used. So far as in proposals are concerned, one other important thing it has done is to say that the seat of arbitration will govern the rules of procedure. Before that, there was some confusion about seat and place and venue and everything, so all that has been set at rest. And so today what the law says is that the seat will be the place. We've accepted the international judgments on this, with which the procedure, the proceedings, wherever it's going to take place, has the most intimate connection, and therefore that law would apply. And where the contract is silent, then automatically the procedural law of the place where the arbitration is going to take place would apply. So far as the substantive law is concerned, of course, it's open to the parties to decide what it is. So far as international arbitration, commercial arbitrations are concerned, the court is, the amendments are by and large, very hands-off. What they say is that we will not fix the structure of the fees or anything, nor are we going to put a time schedule on anything. But if a foreign award is going to be implemented through Indian courts, then the courts cannot review the judgment on merits. They'll have to restrict their scrutiny to only 1 or 2 points, whether it can be, implemented in the country. And the word public policy of India has been given a very, very narrow definition, so that it's not made a reason for setting aside awards. So they've tried to do things to tighten the law and to plug the loopholes.
Thank you, Lata. Sorry.
I just want to add one word. I want to say that this whole paper I prepared in this presentation, everybody in my chamber, this young boy who's come as an intern, Mr. Sauresh Shetty. I want to acknowledge his contribution, and so too Ratnamala's contribution to the preparation of my presentation today. Thank you.
Thank you, Lata, and confirm what you just said. But as we have just learned, there are a lot of things that need to be done in order to achieve and establish an international arbitration system in India, and it's going to be a very exciting process. And I'm now inviting my friend Edgar Philippin, who is a Swiss lawyer and a law professor from Lausanne, Switzerland, and he will explain to you or talk to you or comment on what Lata just said from a perspective of a country that is one of the best known countries for international arbitration. Philippe?
Thank you very much, and thank you for having me here. It's a pleasure being in Delhi again with you on this very nice occasion of the National Law Day. Indeed, Switzerland has been involved in arbitration quite a long time. The first case I can remember is not from a personal memory, it's 1872. It was a case between the United States and Great Britain, and since then the tradition of arbitration in Switzerland has flourished. Switzerland has been a place for institutional arbitration for a very long time, with ICC arbitration with seat in Switzerland remaining extremely popular, and now for a little more than 10 years also under the auspices of the Swiss commerce chambers, under the so-called Swiss rules, of which you will find a copy on your tables. You will find the rules of procedure and also an indication of the time limits and the costs that can be involved in international arbitration in Switzerland. The concerns that Lata just expressed, the timing of the arbitration is extremely important, and you will find a rule in the Swiss rules that awards should be issued within 6 months of the case being given to the panel. So timing is absolutely a concern under the Swiss rules. The Swiss rules and arbitration in Switzerland have flourished, I believe, in part because the system is very liberal, and the approach is that courts should absolutely refrain from every possible intervention in the process. Of course, things can get tricky in an arbitration, and you might need the assistance of the courts to help you with the process. For example, the formation of the panel. If you have a party that does not designate an arbitrator, there are rules about that. You can go to the institution or to the courts to assist you with that. The courts can assist you with enforcement, but the courts will really refrain from any intervention. In particular, the Swiss perspective about setting aside arbitral awards is also a policy of non-intervention limited to public policy review, which is also very narrowly defined and construed. In international arbitration in Switzerland, you should know that it is possible, if none of the parties has its domicile or seat in Switzerland, it's possible to rule out any appeal about the arbitral award, and this might be one of the reasons why Switzerland has become, over the years, a popular venue for arbitration. What we have now in our rules is that we have a procedure for emergency relief as well, and this can lead to a very quick decision, maybe not a final one, but at least an emergency measure that is taken by the arbitrators, and it's relatively new. We have limited experience with that, but the case we've seen have worked relatively well, with decisions issued in as little as 14 days from the filing of the request. So if time is of the essence, there is this procedure in Switzerland. Switzerland being a neutral country, I would like to tell you a few words about the neutrality and the impartiality of the arbitrators. We have that rule, and that can be checked in front of the courts if an appeal is possible. You can challenge the neutrality or the impartiality of an arbitrator. The rules that apply in Switzerland are the ones that are accepted in international standards. In particular, we will apply the IBA guidelines on conflicts of interest as a valuable working tool, in the words of the Swiss Federal Supreme Court. A final point that I want to make, and then we'll follow the discussion, is that one of the disputed issues is whether cases of fraud can be arbitrated or not. And in Switzerland, you will here as well find a very liberal perspective about that. The fact that there has been some fraud involved does not prevent the arbitral tribunal designated by the parties to be competent. So here are a few opening remarks, and then if there are questions or other ideas, I will be happy to take on that.
Thank you, Edgar. And please, the audience, if you have a question, just raise your hand and we will deal with it immediately. Before we turn to the representatives of, in fact, 4 countries with arbitration institutions, to show you how this works in practice, I will call on my friend and partner, Oliver Alexander, who is a German lawyer like myself, but also has, in fact, started out his practice for over 10 years in Qatar. So he will bring you the Middle Eastern perspective.
Thank
Oliver.
Thank you, Axel. I'm also very happy and glad that I can be in India. I've been working with Indian businessmen for many, many years in the Middle East because the Indian community is one of the major pillars of the Arab society in the managerial positions, and then now I'm really pleased to be here in your home country for the first time in my life. The Middle East, I think, with regards to arbitration, it could be a very interesting role model for you Indians to study because in Arabia, with all these new large infrastructure projects coming and companies tendering from all over the world for these projects, and having then an Arabic legal system brought most people or international companies to the idea to actually not go to local courts, but rather seek their luck at the arbitration centers. And the different countries in the Gulf states, they have heard this and started to set up their own arbitration centers. Most of the GCC laws have arbitration rules as local rules. They incorporated mainly the UNICITRAL model laws into procedure rules. For example, there are Qatari arbitration rules, there are Emirati arbitration rules, but they have also set up different centers for arbitration under the Chamber of Commerces. So the Chamber of Commerces in the different countries, they have their own arbitration rules. And on top of that, you might have heard there are financial centers. There's a very famous Dubai Financial Center. There's a Qatar Financial Center. In those financial centers, again, they have their own arbitration rules. So in these rather small countries, you have suddenly so many arbitration centers popping up, and they all are in competition to each other. In addition to that, you have the international well-known arbitration authorities, like the ICC is, of course, predominantly there. You have the London Court of Arbitration and Singapore. We will hear later more about it. And Switzerland, of course, is also always regarded as a hub for, I would say, larger arbitration. So I can only encourage you